Hello, my name is Melanie Popper, and I'm an attorney with the Revelatory Center for Arts and Law in California, in Berkeley, California. And today we're going to be discussing the topic of welcomeness and sexual harassment under California law and federal law. So welcomeness is one of the elements that must be, well, disproven in a sexual harassment case. You have to show from the plaintiff's side that the conduct was unwelcome, among some other factors. But this is a common defense that employers use when faced with a sexual harassment case. The Eeoc, which is the federal administrative agency charged with investigating complaints of sexual harassment, they've given some guidelines about welcomeness. And the California counterpart to the Eeoc is called the DFEH, the Department of Fair Employment and Housing. They've also given some guidelines, but California attorneys do look to the Eeoc and to federal law to work on our cases. So the Eeoc has said in number 915-050, and this was in 1990, that welcomeness has to do with whether the conduct was something that the person submitted to, submission to the conduct as a condition or term of employment. But that again begs the question of what conduct? What is unwelcome conduct that is a term of employment, or a condition of employment if it's submitted to? Interpreting again, the Code of Federal Regulations says that welcomeness has to do with the totality of the circumstances. We look at the whole situation, courts do, and it's on a case-by-case basis, and that's set forth in the Code of Federal Regulations. It's 29, section 1604.11b. And it says, look at the whole situation. What was the person really going through as a whole? Some examples of welcome conduct might be if a person was laughing along with the conduct, whether it was verbal or physical, or other types of conduct like getting emails or posters or hearing jokes, that sort of thing. Were they also making jokes? Were they smiling, laughing, going along with it, participating in it? Some people even go on dates. This comes up more often in cases of quid pro quo sexual harassment, and in a previous video discussing the difference between quid pro quo and hostile work environment, which are two separate forms of sexual harassment. We go over that difference. And there's also waiting too long to complain, as well as just simply ignoring the conduct. These things can be taken as, oh, well, you didn't really mind, it was okay with you, the conduct was welcome, therefore you don't have a sexual harassment case because you can't meet that element. But it cuts both ways. The Supreme Court in Meritor Savings Bank versus Vinson, they said that it's not really the voluntariness of the participation that matters, but whether the conduct itself was unwelcome in an offensive way, whether it was deemed to be offensive. But again, what does that mean? Some things that we can look to that the courts have said, yeah, this shows that it was unwelcome to the victim, to the plaintiff, the person suing, is if they made a written complaint. If you sent an email or a fax or even a text message saying, I'm not okay with this, I'm being sexually harassed, this is the conduct, and I don't like it. Or if they say, they just say no, or they make a verbal, otherwise verbal complaint, or they tell other people, I'm really not okay with this. Those people can serve as potential witnesses to show, well, this conduct was not welcome, therefore we've met that element. Other things are looking at the person's demeanor, their facial expressions, other signs of circumstantial evidence of the conduct they deem to be offensive. So the takeaway here is that it's important to complain, and complain as clearly as possible and as often as possible. However, it's also important to note, though, that when making a complaint of sexual harassment, it's best to follow the employer's policy or manual, if they have one, for making a complaint. Because there's a case that came out in 2003, State Department of Health versus McGinnis, And that case, the court said that there is what's called an avoidable consequences defense. This is a California case. And it means that when, there's a three-part test, but it comes down to this. If a person unreasonably fails, and that word is important, unreasonably fails to follow the policy for making complaints that could have prevented the conduct and corrected it, then their monetary damages are cut. It doesn't mean that the company's not liable, because in cases where supervisors harass employees, the company is strictly liable. They're immediately liable if it's, sexually harassive conduct. However, the monetary damages, what you could be compensated for, the money damages could be cut because you didn't follow the policy. And it's kind of fair to employers. You didn't give them a chance to really know what was going on and correct it. And if you had done so, maybe it would have stopped. They could have done something about it. It doesn't mean they're not liable. But again, what difference does it make to a person filing a civil lawsuit if the damages are cut? So it's important, again, to complain clearly about all of the conduct in writing. Keep a copy for yourself. That's the takeaway when it comes to welcomeness. Make it absolutely clear that the conduct is offensive. So that's all we have today on welcomeness. Thank you very much.